Okay, this is The History of Disabilities by Kayla Zimmerman. So one disability that I thought was important was the 1972 Wyatt versus Stickney. It took place in Alabama. Here I have a map of Alabama. Disinstitutionalized persons have a right to treatment, including education, based on their 14th and 8th Amendment rights. And then there it is continued. The ruling led to sweeping reforms in the nation's mental health systems and the creation of minimum standards of care and rehabilitation for people with mental illness and developmental disabilities. The next one I have is in 1984 Irving Independent School District versus Taro. In this Disability Act, the medical treatment, which is example clean intermittent catheterization, needed for the child to attend school is a related service that schools must provide. And here I have a picture of a catheter in case people don't know what that is. In October 1979, the Taros filed an action against the district, the Texas School Board of Education, and others. They sought an injunction requiring the district to provide Amber with the CIC, which is the person they were talking about. The next act that I was talking about is 1988 Honig versus Doe. In this one, the suspension or expulsion represents a change of placement for students with disabilities. Multidisciplinary teams must determine a more appropriate service plan where students engage in problem behavior that is deemed to be the result of a disability. And here I have a picture of a handicap sign, and Jack Smith was another handicapped student whose disability caused behavioral problems. Smith brought action in district court essentially identical to the one brought by Doe. Smith eventually joined Doe's lawsuit. And the next one I have is 1989 Timothy W. versus Rochester, New Hampshire School District. In this one, regardless of the severity of a disability and the amount of expected benefit, every child is entitled to a free and appropriate education. In this one, on March 7, 1980, the school district decided that Timothy was not educationally handicapped. He was not capable from benefiting from an education. The plain meaning of this act mandates a public education for all handicapped children. And then here I have a picture of just the act of what it was. In this one, I have a 1993 Alberti versus Board of Education. This one says the placement in a general education setting must be offered prior to consideration of a segregated setting. A student cannot be excluded simply because modifications are required. And then continuing on, Raphael's parents visited a number of the special education programs recommended by the school district and rejected them. And then inclusive public education for children with disabilities offers substantial benefits for children with disabilities, for their non-disabled peers, as well as for the community at large. The next one I have is in 1999 Cedar Rapids Community School versus Garrett F. Students requiring intensive non-physician health services to enable them to attend school must have those services provided as related services regardless of their cost. And then this is a map of Iowa where it took place. This also says the Secretary of Education has determined that medical services refer to services that must be performed by a physician and not to school health services. Congress required participating states to educate disabled children with non-disabled children whenever possible. And then I have a picture of a physician that is located right there. This one is a 2005 Schaffer versus Wiest. This party filing a complaint under IDEA bears the burden of proof, and then explaining that is the administration law judge held that they bore the burden of persuasion and ruled in favor of respondents. And they conclude that petitioners had no persuasive reason to depart from normal rule of allocating the burden of party seeking. And then this one is Schaffer versus Wiest continued. Assigning the burden of schools might encourage them to put more resources into preparing IEPs and presenting their evidence. The Act does not support petitioners' conclusion, in fact, that every IEP should be assumed to be invalid until the school district administrator says it's not. And then I have 2006 Arlington Central School District Board versus Murphy. This took place in West Virginia. Plaintiffs may recover fees only for legal representation, not for expert consultants. Joseph Murphy's parents brought legal action to require the Arlington Central School District to pay for their son's private school tuition. And then continued IDEA was intended to authorize reimbursement of expert fees as an exercise of Congress's spending clause power. Any provision requiring reimbursement of expert fees would have had to be unambiguous, which was not. I have a picture of some fees. I have a 2007 Winkleman versus Parma. In this one, parents and children both have enforceable rights under IDEA. This ruling affirms the importance of a parental role. Jeff and Sandy Winkleman claimed that Parma City School District failed to give their disabled son Jacob a free, appropriate public education. In this one, the Winklemans argued that according to the IDEA, any party aggrieved by the findings of a preliminary school district hearing may appeal in a federal court. And then the IDEA does not establish any right of a non-lawyer parent to represent his disabled child in federal court. And then I have a picture of a lawyer. And then my last one is 2009 Forest Grove School District versus TA, and this is a map of Oregon. Parents can be reimbursed for private special education services even when no services were previously received in public school. A former student in the Forest School District sought to be evaluated for specific learning disabilities. And then the hearing officer ordered that school district to reimburse TA for the private school tuition, determining that it had failed to offer him a free and appropriate public education, and the U.S. Court of Appeals reasoned the IDEA provided the court's broad discretion in order to achieve equitable relief for disabled students, including reimbursement for private school tuition.